Director of Dispute Resolution Services. She has been with CPR now, is it a full year, Natasha, I think?
Yeah, a full year.
Prior to being with CPR, Natasha worked with Alarity in Atlanta, and prior to that with the American Arbitration Association. So she comes to us with a number of years of experience. And Natasha is going to moderate our panel today. So Natasha, let me turn it over to you.
All right, thank you everyone again for joining us. We are moving into the panel discussion portion of our event, which is using dispute boards across industries. I'd like to start by introducing our speakers. First up, we have Deborah Maston. Deborah is a longtime CPR neutral and co-chairs the DPMB task force with Mike Lampert. She arbitrates and mediates complex commercial and construction disputes. Before becoming a full-time arbitrator and mediator, she spent over 35 years as an assistant county attorney for Miami-Dade and Broward counties in Florida, where she was involved with major infrastructure projects, including multi-billion expansions of Miami International Airport and Fort Lauderdale Hollywood International Airport, theaters, bridges, tunnels, power plants, and other government facilities. She is a past president of the Dispute Resolution Board Foundation Region 1, USA and Canada, and is a fellow CIR, American College of Construction Lawyers, College of Commercial Arbitrators, and Dispute Board Federation. She is an enthusiastic supporter of early dispute prevention, and Deb is right there in pink. You like to say hello? Next, we have Michael Lampert, who is beside me. Mike has been a sole arbitrator, a chair, a wing, and an emergency arbitrator for AAA, CPR, LCIA, and ICDR, among others. He has been a mediator in private and court annex matters. Before, he was Deputy General Counsel of a major financial services company with global responsibility for litigation, employment, IP, and other areas. His responsibilities were broad-based, both geographically and in areas of law. Hong Wang, who is on the screen as well. Ms. Wang carries 25 years of legal experience practicing corporate technology and commercial law in New York with substantial dispute resolution experience as counsel in select arbitration and litigation matters as a seasoned arbitrator and mediator. As counsel for clients, Ms. Wang has managed multi-stage long-term commercial transactions, including R&D projects, cross-border transaction, and legal proceedings involving multiple jurisdictions. Ms. Wang possesses a holistic view of the transaction cycle and dispute resolution cycle. She is accustomed to engaging various stakeholders and has practiced law in both common law and civil law countries. We also have Duncan McKay. Duncan McKay is Deputy General Counsel and Chief Compliance Officer for Eversource Energy, a Fortune 500 energy and utility company with over 4.4 million electric, gas, and water customers in New England, and a longtime member of CPR and a signatory to CPR's 21st Century Pledge, Corporate Policy Statement on Alternatives to Litigation, and Dispute Prevention Pledge for Business Relationships. He has also served on the Dispute Prevention and Management Board Rules Drafting Committee. He has been active in the development and implementation of proactive approaches to preventing and managing disputes involving the Eversource companies, including the implementation of stepped ADR clauses in commercial contracts, early case evaluation, and conflict intervention, and consideration of ADR options in the early stages of conflicts, disputes, or litigation. So thank you again to all of our speakers. We will first hear from Deborah Maston. If you could please tell us a little bit about the DPMB concept and give us a historical background.
Sure. So Natasha, thank you, and welcome to everybody who is interested in this. I'm going to start with the Cliff Notes. So the Dispute Prevention and Management Board concept is the only alternate dispute resolution structure that looks forward, not backwards. It is preventative in its primary objective, and although it can deal with resolving unresolved disputes if it has to, but that's not its primary function. So those are the Cliff Notes, looking forward, not backwards. It is a project management structure that supports early avoidance or mitigation of disputes. Because in complex contracts, whether they're construction or in other industries, as Duncan's going to get into, stuff happens. Those things that are unexpected could be late discovered design defects, delayed performance, unexpected events, think COVID, supply chain interruptions, weather. Things happen that interrupt the natural progression of a transaction that people have contracted for. And the parties need to adapt and adjust. And this is a structure that supports that activity. Non-payment, third-party interferences, contract ambiguities, or misunderstood interpretations of the contract. This is a structure that is designed to allow the parties to amicably resolve those things before anybody has expended resources. And while there are more choices available, cheaper solutions, the concept is the earlier you can address the unexpected or the unavoidable, the less impact or the less adverse impact it will have on the project. So the Dispute Prevention and Management Board was born from dispute resolution boards in the construction industry, which explains my presence here. I've written a paper about that, which is in the materials that's been given to you. If you can't sleep tonight, that you can look at it and get a deeper dive. The way this is structured is the appointment of 3 industry professionals. This is not arbitration light. These professionals meet regularly, not just after a dispute surfaces. They are prophylactic. They meet in advance on a regular basis, whether or not there are problems on the job. And they address the parties in what my British friends refer to as an inquisitorial manner. They ask the unpleasant questions in the nicest possible way. This is not an adversarial proceeding. There's no attorneys representing clients typically, unless it gets further down the line. There's no cross-examination whatsoever. Board members question the progress and the status of the project. And in doing so, they force open communication between the parties. Sometimes project personnel, don't want to disclose an event that has happened that's impacting the progress of the work. I'll handle it. When we get there, I will handle it. It's under control. This is a structure that forces open communication about the unexpected, unpleasant things that interfere with the intended progress of the work. It works because it's confidential, because the decision makers are at the table, because non-party stakeholders can be invited to participate in these conversations and subject to the confidentiality. There are no ex parte communications. This is not like mediation. It works because of the trust that's built among the panel members and the project parties. And ex parte communications tend to disrupt that trust. It prevents disputes from aggregating. It maintains relationships. It provides for a structure that gets buy-in for a path forward from all the parties. And it's done in real time while the project is underway. Again, looking forward, not looking backward about who made it wrong and who's going to pay for it now. This is, we have a problem, and collectively as a team, how are we going to address it? It works at the project level. It's not a step negotiation structure. And if necessary, it can convert to an arbitral-like panel that issues a recommendation that is binding on the parties during the remaining life of the project or endeavor, subject to reevaluation by a real arbitral panel at the end when everything's over. Side benefits that we found is it can validate decisions to compromise. In many cultural structures, if a project level person compromises, they are not looked on with favor in their own internal structure. Their boss or their boss's boss says, you know, why did you fold? Why did you give in? This is a structure that supports collaboration and minimizes adverse impacts to the actual to the participants for coming to a compromise and not being pugnacious. And the other benefit is it's dramatically cheaper than other ADR or that remedying a contract breach or that litigation. The statistics are very interesting. So it works.
July 31st, 2023.
Yeah.
AI is taking over.
It works. So let me show you real quickly. The slides have been given to all of you, but let me show you real quickly slide number 15, which has a few little statistics on it. This is the University of Washington experience. University of Washington was a very early adopter of dispute boards and in a very collaborative community, I will say. Keep going, keep going. It should be a picture. There should be a picture there. There it is. Okay. So this is an old slide. It was done years ago, but in their first 40 contracts that they used it on, construction projects totaling over 40 billion in construction value over 20 years, there were no formal dispute hearings by the board. They worked it out among the parties. And that's considered to be a successful and appropriate board result. They're not supposed to be sitting in arbitral-like proceedings all the time. They're supposed to be collaborative, conciliatory, facilitative, and a lot of that is due to the selection of the panel members, which we'll get into later. And so let me go to I think it's slide 23. My war story, pictures. There we go. All right, back, yeah, the Arts Center. All right, so my first dispute board was on the Arts Center, which is a very complicated, they called it jewel box structure. It has no two members that are the same dimension. I did it all wrong. I used to give a talk on 10 ways to screw up a perfectly good dispute board. We picked good board members, but we didn't let them meet. By the time they met, the project was 2 years old. There was a backlog of unaddressed disputes, and we started to tackle them. We were essentially in arbitration hearings every month. Every month they would meet and we would have a hearing about something that happened 2 years ago, a year ago. They're on the 4th floor and we're talking about what is the impact of the power company not moving its transformer timely. And the panel members kept saying to us, "You're not using us properly." And I'm a very competent construction lawyer. I know what I'm doing. And it got to be so painful that we agreed to get rid of the dispute board. We're never doing this again. I mean, there was 24 people in the conference room every month, and we're looking around the room going, who's building our job? All the project management people are here with us. They're not on the job building it. This is stupid. And we got rid of it. So my next slide, was North Terminal Development at Miami International Airport. It was a $2 billion project, which we took over from American Airlines as our developer tenant. The county took it over. It was incomplete. It was an operating airport. There were environmental hazards that had to be remediated. There were contractual claims that had to be addressed from the contractors, designers, subcontractors, vendors, and the the construction manager who took over the job for us after a new procurement period told us he'd give us a better price if we put in a dispute board. And I'm saying, don't do it, don't do it. And my client said, yeah, I want a better price. So we did it. And this project ended with no claims, no mediation, no litigation, no arbitration. There were change orders. It was an enormously successful experience for the staff and for the contractor. And it was then implemented. It was like the pilot project. It was then implemented in future projects because it was so wonderful. So that's when I drank the Kool-Aid and became an advocate for the appropriate use of dispute boards. I will say that I have been invited to sit as a dispute board panel member on dispute boards over the last few years, and none of them have been done properly. They were all boards that were created after the project was ended to deal with residual claims. And I'm here to say that's a bad idea. You know, we have arbitration, we have litigation, we don't need to reinvent that. This is not a substitute for that. It is a project support mechanism, looking forward, not looking backward. So let me just check my notes. And I think I will turn it over.
Right, well, thank you. That was very informative. We will be moving on to Duncan McKay, Duncan, can you, as General Counsel, tell us about how this concept is used in other industries?
Sure. Thanks, Natasha. And just to build on what Deb said, my first introduction to the concept of a dispute prevention board or dispute review board, I was about 15, 20 years ago, and it was with the DRB Foundation, and it was in the context of course, construction. And I was introduced to it in the context of the Boston Harbor project, which was a multi-year project. And like the examples that Deb gave, when I spoke with the folks who were in charge of the DRB for that project, they were explaining how the DRB worked and the fact that disputes were addressed before they blossomed into something that would require time away from the work at hand that could potentially interrupt the schedule of the project. And like the examples that Deb gave, when that project was completed, again, over multi-years, there were very, very few disputes that moved on to mediation, let alone arbitration. And I thought, well, you know, wow, this is powerful stuff. And we for years have been advocates of finding alternatives to litigation. And so as Natasha mentioned in my intro, we've used the multi-step CPR clauses in our commercial contracts since I've been here, and I've been here for 28 years. And so we believe very firmly, I believe very firmly in the concept of getting in early. We train our lawyers in our legal department who are embedded with the business, that when they sense that there is a potential dispute in the offing, to get involved. Let's get involved. Let's try to resolve this at a business level early on. So the concept was there, but the stepped process didn't really, allow for a formal intervention. So I thought with this introduction to DRBs that, well, why couldn't that apply to our business? We're in the energy business. We're a utility. We do large multi-year projects, whether it's transmission line builds or upgrades, gas distribution pipelines, power plant construction, offshore wind construction. And there's a whole range of things that have a lot of the same attributes that road, bridge, tunnel construction have. So if it works in the construction industry, why not in the non-construction world? Why not in larger projects? And so we started to play around with ideas, but all we had to go on at the time was what was existing in the construction field. And so we took a couple of efforts at trying to imagine what a dispute prevention board might look like in our business that was not necessarily in the construction context. You know, where we have, again, long-term project, the folks that we're working with, our counterparties, are folks that we have long-standing relationships with, that we need to maintain very constructive business relationships in order to do the job that we need to do to keep the lights on, to keep the gas flowing, et cetera. You know, it's important that we are maintaining, not getting sidetracked with costly litigation, even through the multi-step dispute resolution process. These are folks that we're going to continue to do business with. It's a relatively small industry in terms of the folks that are involved in what we do. And so, you know, experiencing any distractions, disruptions can be significant. So we looked at ways that we can apply the concept of the DRBs in our normal business setting. And we had a large project now about 10 years ago of outsourcing a large part of our information technology function. It was something brand new for us. We didn't know a lot about it. We used to do all of our IT in-house, and now we were going with a different model. We were going to be working with two principal suppliers during this entire project. And the potential for things going off the rails and us not being really comfortable or familiar with this area really drove us to think about how might we use a standing neutral to help us. Somebody like a DRB that might meet regularly with the teams to help us identify potential issues, maybe even before we recognize that they were issues, and resolve them right at the time, so we don't end up in the final phase of any project being the litigation phase. We wanted to avoid that phase. We wanted to make sure that things worked well. Well, I'm a little embarrassed to say that our process probably fit Deb's definition of we did it wrong, but we learned a lot from it. And indeed, it drove me to really be a champion and advocate for CPR's DP&B concept, because that does provide a strong framework for this. But we kind of made this one up based on the DRB concept, but it worked in a funny kind of way. And that is, we had a standing neutral who received all of our contract documents, got a briefing on what the project was, but he met with us very few times. And it was primarily in the beginning as the parties were getting to know each other and to getting to scope out the project. But simply having the standing neutral there, the parties aware of what the process was for identifying and addressing disputes early on, we ended up never having to have a formal DRB or a formal intervention by the standing neutral. He was there, he was compensated, but the parties, whenever they had a potential dispute, said, well, geez, we really don't want to drag this in front of the standing neutral. Let's figure out how we can resolve it. And we had no litigation coming out of this multi-year process. It wasn't a perfect, dispute prevention board experience, but it certainly showed the potential benefit, as Deb outlined, the potential benefit of having, whether it's a panel, a group of three, and you'll hear more about, the different compositions of the dispute prevention board, can be three or it can be one. Ours was one in this case. But it served a real purpose of focusing the parties on their common interests. The having that standing neutral really drove alignment of interests and making sure that, listen, we all have a goal in mind. It's a common goal. Let's figure out how best to get there. So an imperfect example, but certainly to me showed the promise of what a strong standing neutral can be. And CPR has done some great work around standing neutrals. And the DP&B concept really is an outgrowth of that. Bringing this now and borrowing from the construction industry to say, hey, this works in the construction field, but this can work in the commercial context too. Why can't this work in a situation that has nothing to do with construction, like our outsourcing? We've tried this again in small ways with regard to technical experts when we have large design projects and multiple parties involved, to be able to help the parties identify and address technical issues or disputes early on. So not necessarily legal issues, but where there's maybe a technical point of view that's different between the various parties. Having a standing neutral with technical expertise can also help facilitate the identification and prevention of these from blossoming into something that we had historically again found wouldn't get raised until long after the project was done and long after we've energized something. Now we deal with that final stage, and that's just not an efficient or good way or smart way to do business. So being involved in this process with CPR, it was a great opportunity to work with a superb team in putting the DP&B concept together. Now gives us some real tools as in-house counsel. It gives me some real tools, and I'm thinking all the time about how we can use these DP&B concepts in our business as we move forward in non-traditional ways. And I think the promise is really there. And it really gives us an opportunity to, again, accomplish what we try to accomplish as in-house counsel, which is to minimize the distraction so the business can accomplish its objectives by intervening early, identifying and addressing, preventing disputes early on if we can. And this process provides a structure that is easily adaptable for many businesses. And we certainly think it's got promise for us as we move forward. And we can take our failed experiments, which again, I don't think were necessarily failed. We learned a lot from them, but certainly not a perfect DRB concept or dispute prevention board concept, but all of the attributes are there. So I appreciate the opportunity to talk with everybody about this. I really encourage folks on the business side look at these rules, because they really do have a lot of benefits to make sure that the business can focus on its core purpose, which is the business. It's not disputes. So I'll turn it back to you, Natasha. Thank you.
Thank you, Duncan. Now we will have Mike, who will give us a little bit about how to adopt this concept.
All right, so before getting into that, I'll take a different sort of small point about starting, which is you've heard several things about how CPR's interest in this got started. And let me be quite clear, CPR actually received requests from a couple of lawyers in a couple of industries to say, we've heard about this in the construction industry, do you think it would work for us? And so those requests have occurred in the pharmaceutical industry. They've occurred with respect, which are long-term projects, often with unrelated players, corporately unrelated players. They've come in the major software development industry, which you to some degree heard just talked about by Duncan. And they came in several other areas. My background, as Natasha indicated, was in the financial services industry. And certainly there were joint ventures and buyouts where there are going to be adjustments down the road, all of which might be amenable to the notion of somebody coming in early and trying to deal with the problem. And look, I would say in the course of this discussion, so I have a sibling, I had parents. My parents were very good at predicting when my sibling and I were likely to engage in a dispute and preventing us from doing that. And to some degree, that's the role of the neutrals here, is to foresee a problem that the participants may not see, to watch to know what's going on. And as Duncan mentioned, the other parental role is the mere presence is nobody wants to say to their sibling, I'm going to mommy, I'm going to daddy. In the example he used, people didn't want, the DRB was successful because nobody ever used it. Because people admitted they were, I won't say in fear, but didn't really want to use the process. So to some degree, that's how CPR started, because the notion is, as has been indicated, this is largely a construction vehicle. And so you'll notice that the rules of the system in CPR are actually not called DRBs. They're called dispute prevention and management boards. And that's part of our attempt. CPR created a task force of about 30 people. Deb and I were the co-chairs. There were a number of working committees on the task force. The rules and clauses I'm about to go into are all the result of a committee of that task force. There's also a committee on how do we qualify people, how do we train people. There were, as I say, 6 committees, and Deb and I attended, I think, virtually all of the committee meetings, and this process followed. So how do you actually start an individual DRB? Micah, if you could go to slide 9. We have provided, and this is all available on the website as well in terms of model clauses. Micah, you there? Do we have slides? There we go. Okay. Go back to model clauses. That's the one. One more.
Go back.
Go. It's the next slide after that, I think. Keep going. It's the one that says model clauses for CPR. There we go. So I don't like slides with lots of text, but if we're going to show you what's up on the website and at least point out some of what we considered and what it means, so you'll be educated about it, we sort of need to put the text up. So this is a model clause. You're free to play with it, although the group put a lot of discussion into it. And to the extent I say play with it, when we talk about the rules, which will be in the next segment, in the rules, there are a number of places where there are switches. Do you want 1? Do you want 3? People are familiar with this in the notion of arbitration. When you do the creation, you need to sort of address those issues. So we thought it important in the clause, because this is somewhat new, to say, why are we doing this? What's the point? And so you can see the italicized: assist in the prevention and mitigation of disruption as a result of events, and it doesn't say both, but it means both, arising between the parties or stemming from external events. As somebody already indicated, COVID, certainly clauses, there may have been clauses about force majeure, but do you think anybody really focused on the particular instantiation of a shutdown for 2 years, interference in supply chains, et cetera, from a vaccine? If you have a dispute resolution process, you talk about, okay, this is something we really didn't plan on. It's not something we addressed in the contract. What do we do now that seems fair and just and moves this thing along? Micah, if you can go on to the next slide, please. So endeavor is a defined and unusual term. It's not really in the lexicon of dispute resolvers to date. Endeavor means the entire scope of the venture. What is it people are trying to do in the real world? Agreement is between some parties and establishes the rights and responsibilities of the party to participate in the endeavor. The intent is to facilitate contemporaneous agreement as to the resolution of unanticipated issues, to predict and resolve those issues before people develop stakes, before people develop positions. And if that fails, if it can't be resolved quickly by chatting, and so here, the dispute resolver needs essentially mediator skills and an awareness and understanding of the particular endeavor. And notice we didn't use the word project, because project comes with a lot of historic construction overhead. And we meant to be able to say, this is something more than just construction. So we lit upon the new word endeavor. But to go back to the end, if talking won't resolve it, talking with the involvement of a neutral, then the dispute resolver, whether it's a board or an individual, can provide written recommendations. Think of it as a mediator's proposal for the resolution of the dispute. Can we have the next slide, please? And this is all, it's meant to be in the model clause because these are things you need to lay out when you're deciding what form of board you want. And then whatever, if the dispute resolution board, dispute prevention and resolution board has to come up with a recommendation, and we'll talk in a minute about the rules and how that all happens. That is provisionally binding. This is what the rules provide, and it's what this clause provides. And what that means is often somebody who's got economic leverage tries to use it during a project. Somebody needs money, somebody has money. The dispute resolver is entitled to say, for the time being, you with the money have to pay the worker, the company that's doing the work. And if the other side doesn't object within 15 days, that provisional recommendation becomes final. But if the other side objects within 15 days, everybody has to obey that recommendation, but has a right to commence an arbitration to revisit it ultimately at the end of the dispute. But the goal is to keep the endeavor moving. And so it's kind of funny, non-binding arbitration, right? So is the arbitration binding or not? And again, you write this into your clause or can rely on the rules. And then in some instances, it may be useful to actually convert the recommendation into an award, presence of third parties, insurers, whatever. We, in the rules and recommend in the clause, people talk about that, and we provide that you can ask for a sole arbitrator to enter a consent award that embodies the recommendation. So now you have an award which would be enforceable under the New York Convention if it's international, under the Federal Arbitration Act if it's state. But the neutral under the agreement can't do this. We want another person to do this because we think actually entering an award, there's a whole lot of overhead about sort of bias and all sorts of other things that the or mediation convention, consent arbitration awards are not uncommon in the arbitration field. We have the next slide, please. And then if you're going to write this clause, you have to then, well, I don't have to. If you wanted, you could say that at the end of the contract, if somebody's given due notice that they don't finally accept the recommendation, in the absence of an arbitration clause, you can go to court. We think that's not the most productive way to deal with the dispute. So we encourage people simultaneously with adopting a dispute prevention and resolution board concept to also go to CPR's arbitration system, maybe to go to the fast track system if that seems proper. But again, when you're drafting a clause, because you want to start this process, you need to think about these kinds of questions down the road. And so that's sort of my piece for this part, and I'll return it to Natasha.
All right, thank you. Tong is going to highlight some of the rules. Mike showed us the clauses, so Tong, if you can just highlight some of the rules for us.
Yes, of course. Thank you, Natasha. It's been amazing to work with our frontiers and veterans in the dispute boards field and take part in some of the drafting process of these rules as a member of the task force. And it's such a pleasure to be here today with our audience, the CPR leadership, and thanks to Baker Donelson for graciously host this meeting. I'm happy to provide a quick overview of the rule itself. One of the great things about these rules is they come with a flowchart. It's a good illustration of how the DPM board works under the rules. Micah, if you could please upload the slide 27, that would be great. Thank you. 27, I think. Yes, it is. As you can see on the chart, the top portion is the trunk. Steps 1 to 4 illustrate how the board functions by having regular meetings with business representatives of all parties through open discussion or informal recommendations to parties. Assume most issues would be handled, resolved, or mitigated this way without need for a board hearing. And the branched out portion from the middle down illustrates how to initiate a hearing before the board when there is a formal disagreement. You can call it a dispute, which kicks in only when issues persist that cannot be resolved through the regular meetings with the board. It may be counterintuitive to some or to many, but as speakers before me have emphasized, it is this routine, regular meetings, not the hearings, that constitutes the central mechanism through which the DPM board functions. Regular meetings with party representatives as part of a team is how the DPM board achieves its dispute prevention and mitigation function. That is, be there before a dispute actually materializes or grow into something unworkable. We will talk about this in more detail when we review the rules together. The first tier branches in the middle tell us how to initiate a board hearing by filing a notice of disagreement for recommendation, written recommendation with the board. Once a hearing is held and the recommendation issued, such a decision by the board will be automatically binding on all parties during the term of the contract. Someone might want to ask, what if I don't agree with the board's decision? Am I stuck? Of course not. That's why we have the second tier branches in the bottom portion. They tell us how to preserve your right to challenge the board's decision in future arbitration or litigation. And the default of the rules, you must file a written objection within 15 days. In that case, as an objecting party, you may refer the disputed matter as preserved before the legal action at the termination of the party's contract. We will elaborate a little more about this point later. Please stay with me at the second tier branches here. The left branch shows if the board does not receive a timely written objection, the board's decision will become final and binding as between all parties and may not be challenged afterwards by any party. Remember, this DPM board rules operate entirely as a matter of contract. It essentially means that the board's decision became parties' contractual obligation to implement and abide by, and will give rise to a breach of contract claim for non-compliance by a party. On this flowchart, you will also find additional notations in those 3 lines of the blue tiles. For example, the blue tile at the bottom talks about the 3-step condition precedent to assert claims in further legal action, as illustrated by the chart. In order to preserve a disputed matter for arbitration or litigation, a party must have gone through 3 steps. Namely, it must have raised the issue at a board's meeting. It must have filed a notice of disagreement, and it must have filed a timely written notice of objection to the board's decision. Again, obviously, all of these are enforced as a matter of contract. They are not self-executing. Thank you, Mecca. Feel free to remove the slide. Thank you. Now, I hope you've got a basic idea of the framework and the processes of these rules. Next, let's take a closer look of the rules. They are quite concise and streamlined, consisting of only 6 rules. In your slides, you will find a table of contents of the rules. Very quickly, Rule 1.1 makes it clear that these rules are elective and parties may modify them in writing in their contract. Rule 3 concerns composition of the board. You will see it's a typical neutral selection process. In all instances, the board will function as a body of neutrals and enjoy the immunity afforded to neutral professionals. Functioning of the board is addressed by Rule 2, Rule 4, and Rule 5. Rule 2 makes it clear that the primary purpose of the board operation is dispute avoidance. Issuing binding decisions is only the secondary function of the board. In other words, the biggest success possible for a DPM board would be achieved if it never needs to conduct a hearing. Not bad, yeah? Which would means all issues would have been otherwise diluted or resolved through informal discussions at the board meetings. Rule 4 covers the board's meeting. The secret sauce here is the confidential settlement discussion treatment afforded to all discussions occurred in these meetings, regardless if there is any disagreement or potential dispute. This is reflected in Rule 4.3, also Rule 2.2. The goal here is to mitigate against any potential prejudicial effect to the maximum degree possible and let participants kick around options in these meetings. This is how the DPM board achieves its dispute avoidance function to foster a informal, relaxed, and teamwork environment. Consistent with this goal, meeting discussions are completely informal. Verbal communications is desirable, and formal or written record is not favored. The rule also allows participation of the board's meetings by third parties, subject to agreement by all of confidentiality and meeting protocols. See Rule 4.1. As frequently the case, there are often third-party stakeholders to a transaction, downstream or upstream or both, who may affect or be affected by a party's potential chosen course of action. For example, it could be a significant customer, a significant supplier, or it could be indemnitor, indemnity, or intermediary. However, note that despite the informality of the board's meetings, ex parte communication with the board or board members is strictly prohibited. Inside or outside meetings, of course, is how it should be. See Rule 4.4. Rule 5 is about hearing and the board's written recommendations. As we saw in the flowchart, a notice of a disagreement in Rule 5.1 will trigger a hearing. Consistent with the board's role to facilitate teamwork in dispute management and preservation of relationships, by design, the board's hearing is a much watered-down proceeding compared with hearings most of us are accustomed to. Less adversarial and less contentious. As you will see in Rule 5.4 and 5.5, the board's hearing is about information collection, not argument of legal positions. Witness doesn't need to be sworn, and there will not be direct or cross-examination. In general, no offense to my attorney colleagues here, attorneys are discouraged to attend the board's meeting and forget about raising legal objections, unless you are neutral. Board hearings are designed to be expeditious, aiming for predictability and timely resolution. You can find those relevant time limits in Rules 5.2, 5.6, and 5.9. Importantly, under the Rule 5.8, by default, the board's decision, once issued, will be automatically binding on all parties during the term of the contract. This is in spite of parties' right to make objections under Rule 5.9. Pursuant to the Rule 5.9, assuming three-step condition precedent is met, timely objection to board's decision will preserve the objecting party's right to raise relevant claims in arbitration or litigation after the contract terminates. However, here's the catch. It's a different question whether such objection alone will be sufficient to preserve objecting parties' claims under the contract or applicable law. That will require a different analysis based on parties' contract and is case dependent. Under Rule 5.7, it is a responsibility of the parties, including objecting and non-objecting parties alike, to do what is necessary to otherwise properly preserve their respective claims under the contract and applicable law. Of course, if no objection is timely filed, it's a merry-go-round. Board's decisions will become final and binding on all parties, become part of their contractual obligations under the underlying contract. Rule 5.13 spells out the three-step condition precedent for pursuing claims in arbitration or litigation, failing which, under these rules, claims relating to a matter would be forfeited under parties' contract. Final words. As stated in the introductory note of the rule, these rules are written for potential applications cross industries, regardless of complexity or amount in dispute. Apparently, they are designed to be elastic. It leaves ample room for parties to fill the gaps in their contract, to tailor-make for their own transactions. This concludes my review of the rules. Back to you, Natasha. Thank you.
All right, thank you so much, everyone. We will move into a question and answer portion, but I would like to do a little shameless plug. CPR does also have an case administrative services. We do that separate from the Institute. It's called CPR Dispute Resolution Services. Myself and my colleagues, Mia Levy and Nancy Bastardas, work as a team to administer disputes. With the Dispute Prevention Management Board rules in mind, CPR DRS is available to assist the parties with the selection of the dispute board members. We would also help facilitate if there is any issue and we need to do administered arbitration, you can file that with CPR DRS. We do have a separate website, which you can link to on the Institute website. We have fee schedules that are available. The fee schedules for the Dispute Resolution Board is also available within our website. something that is unique to DRS that other ADR providers do not utilize is our query and nomination process. So if a case was filed with us, we would at that point immediately schedule an administrative call with the parties to get some, go over the procedures and hear about the selection process, what you are looking for in the dispute board members or an arbitrator, if that is the process that is selected. We do maintain a dispute prevention panel, which has arbitrators or neutrals who are skilled in facilitating conflict management. So I wanted to go ahead and plug that. When we are selecting arbitrators, and I mentioned our query process, we like to get disclosures up front. We send parties a complete what we call our nomination package that includes rates. You know whether a candidate is diverse or not. You also know their availability. They can provide additional statements of expertise. So just keep that in mind when you are filing your cases that CPR does offer dispute resolution services. I'd like to, if anyone has any questions for anyone, I'd like to open it up to you at this time.
I think everybody has talked about the benefit and the savings of cost. How have the business people found the nature of the formal proceeding and talking in terms of all the parties? Does that work well? Particularly since it's being conducted without lawyers, as I understand it, a lot of the time. I just was curious how. So if I present this to my clients, how they react to it.
Yeah, probably.
Deb, would you like to answer that? Did you hear the question?
You're
You're
muted.
muted.
I got the beginning, but I didn't get the end. What was the ask?
Oh, how, in terms of how have the business folks adopted or embraced this idea, particularly when it's conducted a lot of the time without attorneys in order to facilitate the process? If I'm presenting this concept to my clients, I kind of want to know that background as to why other businesses have found this successful, other than a cost saving.
Oh, all right. So let me say this. When I moved from Miami-Dade County Attorney's Office to the Broward County Attorney's Office, and we introduced this concept to the Broward County Aviation Department, the director loved that there were no lawyers involved. Loved it, but he was suspicious of the whole process. And he agreed to do a pilot project, which was a very small, so we were doing a runway, which was huge. It was, a $1 billion project. But in the path of the proposed runway was a little parking lot for the taxis that had to be relocated. Very small project. And so he agreed to use the moving of and the relocating of the taxi lot as the pilot project. And it was so successful that he imposed dispute board requirement on everything after that. I mean, these projects are particularly good on time-related issues. Time is money, and these large, complex projects, time is very valuable. And so if you have compressed time because of an efficient progress of the work, that is of great importance to the business people. And the other thing that's valuable is, in today's world, when I did these 10 years ago, everything was in person. Now you can do it by Zoom. The meetings can be by Zoom. Anything you need to show somebody can be by drone footage. You don't have to show up and get on a ladder. Technology has advanced. And so the cost of doing this is less than the insurance that you're carrying during the life of the project. It really is insignificant compared to your outcome. The business people, once they've tried it, they love it.
Still can have something to say.
Just to maintain the neutrality of this, who's paying the cost? Is this just
all right,
on the own project?
These rules provide for everybody paying the cost. In in the construction world, there are other models. 50-50. In my contracts, it was owner pays all because we figured the owner's going to pay all anyway. The contractor's just going to, throw it into the cost of the work. The Colorado method was owner pays all for the regular meetings, but if either party asks for a hearing, a dispute hearing, then the costs of the dispute hearing are initially borne by the requesting party and then shared as allocated by the board.
There was someone.
Oh, I was just curious, what is sort of the typical job description of the ideal board panel member? Are they previous lawyers, recovered lawyers? Are they engineers? Are they academics? Are they just people who have a mediation arbitration background? What are some of
So
the?
CPR is, as a result of our task force, putting together a roster of distinguished neutrals for this purpose that already are arbitrators and mediators. And our view was we took everybody who's already on the dispute on the roster who's interested in this area. And some of them had already served on dispute boards, so we immediately certified them. And for all the rest, we're going to have training actually later this month. And how is this different from this? How can you take your skills as a mediator, arbitrator, and apply it in this context? And at the end of that training, everyone who's already been vetted by the CPR process as a neutral who takes the training and has shown an interest will become eligible to be one of these, because this is a sort of new area. There aren't people necessarily with specific experience on this except in this construction context, but we thought that people who had mediator, arbitrator experience and who took the training and were interested would be a logical pool for initial neutrals in this kind of context.
Yeah, and let me add to that industry experience is more valuable than legal experience. These people bring something to the table. Have you thought about this? How are you going to handle that? Looking ahead to your, the next month out, they ask questions that are relevant to the endeavor because of their own professional experience in that discipline. It's enormously valuable to have them focus the team members, the project team members, on issues that they will have to address as the endeavor progresses.
Let me add, just it may depend on whether you have a single or three. So quite coincidentally, some people in Europe recently asked me to be on one of these panels in the construction industry, and I said, I don't have construction experience. You really ought to use somebody who's got some measure of construction experience. And I gave them a couple of names of people who have dispute review board and construction experience. And interestingly, they came back to me and said, so this is a very, very big project. We're thinking 3. If we did 3 and we had the 2 wings be construction people, would you be comfortable running the panel on the process? And to that, I said, yes. So I wouldn't have been a solo and won't be a solo, but if they go for 3, I might yet be chosen to be the chair. So what you look for may vary. And indeed, even the 2 sides may not have precisely the same experience, right? One can think of a circumstance where you want certain kinds of construction experience for one person and a different set of experiences for the other.
One more, I'm sorry to ask a question, but just for comparison purposes, I hope this isn't an awkward question, but the DRB Foundation, is that a competitor to what CPR is doing? Do you work together?
So Deb is active in that foundation, but I'll tell you very quickly and then we'll hear from her. ICC has a dispute board set of rules. AAA has a dispute board set of rules. They are all really construction focused. CPR is not saying you can't bring them to construction, but the vision is to move into other industries. So competitor, I guess, in some sense, but I think CPR would take the view in these other fields, there are no competitors because there's nobody doing it currently. Deb, is that a fair summary?
Yeah, also CPR's scope of services is much broader. The Dispute Board Foundation offers training, but it doesn't create panels. It doesn't certify anybody. It has rules and it has trainings, but it doesn't have the full scope of services that CPR is offering.
But are there certain industries where it makes sense? I know Duncan mentioned in the energy business, it seems like it would make sense, but that's question one. Question two is, why hasn't it taken hold in other industries?
So as I mentioned very briefly, CPR has actually been approached by people in the pharma industry and by people in the tech industry. So presumably if they're approaching CPR, those people think it makes sense. And I think it hasn't taken hold because nobody's had the vision to, people have understood the model, but these rules change the name, change the procedure, had an appointment process, and we're about to certify a set of people who don't all come as a construction background. As I just said, I don't, but who can, I would be really comfortable with a tech dispute because I'm a reasonable techie. And so I think part of it has been creating a pool of people who are capable of doing it, having a set of rules that has a vision broader than that is why it hasn't taken hold, I think. Do we know if anybody on has a question?
Micah, can you tell us if anyone online has a question? Is there anything in the chat?
Nothing, but if anybody wants to, please remind once again, just you can raise your hand and we'll pick you.
I don't know if this is helpful, but what's your name, sir?
Gary Barnes.
Gary, a comment that it just made me think of for your question. I guess the attorney would still have a role, it'd just be more of a consulting role. I would assume that the party, before they're deciding whether they want to object to whatever is happening, they'll probably reach out to their lawyer and you'll either talk them off the ledge or put them on the ledge. So I assume the role will change, but I couldn't imagine who I would, if I was a party in the thing, I couldn't imagine who I would go to decide whether I'm getting hosed or not. You know,
That and the lawyer will be involved up front, the counseling of a preparing agreement.
Right.
This is something you need to think about as a way to approach the problem.
Correct. So see, lawyers are still relevant.
I didn't say I wasn't relevant.
Yeah.
I'm trying to figure out how you can convince people.
Yeah, true.
Sometimes others.
And they might think it's just not
One of my
Right.
clients said to me once, I don't want a lawyer telling me about how to build a truss, but I don't want an engineer telling me about, lack of notice either. So a lot of it depends on the type of dispute that arises.
Do we have any last minute questions? Just another check back, Micah. Did we get any hand raises there?
None right now, but feel free, anybody who wants to ask a question and we'll put you out there.
All right, well, I'd like to thank first our speakers for engaging everyone on this topic. I'd also like to thank both our in-person and our virtual participants for participating and joining us for this session today. I'd like to invite everyone here to a cocktail hour that will be served outside of these doors. So please stick around, engage with my
hosts.
Yes. Oh. Yes, and thank our host, Baker Donelson, for having us here. This was a wonderful space, so we're thrilled. And if everyone wants to just step outside the doors and join us for a cocktail hour. Thank you.
For anyone online, if you would like to have a continue networking online, we're happy to break you out into a room to do so.
Wonderful.
So Micah, maybe we can take the spotlights off and just let everyone who's online who wishes to stay. right. I think this is a small enough group that we can all stay in one room. Any questions in general about the rules, about what CPR has been doing? Anything you want to talk about?
If I may, I think that this time has more than come. Probably 15 years ago, CDRS gave dispute resolution board training. And at that time, it was, of course, in the construction industry. But the concept, and I've floated it with business clients over the years. Some, of course, react negatively, don't want to get involved in something extensive like a DRB. But some clients truly felt as if it was a very welcome concept, because it's not just sitting down with a mediator or a panel of co-mediators. It's being able to bring in some others of experience who are able to assist in a project that could move it forward so much more quickly than we find with normal mediations or arbitrations. So it's all thumbs up from my side, and CPR, congratulations for moving this forward.
We come at it in part from experience. You know, I've been with CPR for 20 years. I think only Russ, who's on the line, has been around longer than I have at this point. And I've been through 3-4 software rollouts, and every software rollout has problems, every single one. And the one that worked the best was the one where we brought in a neutral who had a background in technology, but was also a lawyer, and therefore could understand why I, as the head of DRS at the time, said, I can't shut down DRS for a day. You know, people have statutes of limitation. They may need to file a case. We got to work. The process has to accommodate the fact that we cannot shut down during business days. I mean, we might be able to do it over a weekend, but we cannot do it during business days. But who also talked the language of the tech people and could understand when they said, you know, they had to do ABC or, you know, 1, 2, 3. And so this is something that we've experienced. And one of the reasons that we thought that the time was definitely right to go forward with this concept. And we did, to be fair, we did start this, what is it now? 3 years ago, because we, as Mike pointed out, we had a number of different working groups working simultaneously on drafting the rules, on recruitment of the panel, on putting together a training program for the panel. And we have ongoing a working group that is going to address outreach to the various industries, you know, that are not necessarily the construction industry.
A few thoughts come to me now, and as you speak of outreach, probably important also. In earlier years, I represented a kingdom, a country, and its United Nations ambassador. So that got me used to being, and I was based in New York then, at the UN and meetings and the like. Completely separately, I was invited to present some programs at the United Nations based upon dispute resolution and the like. A few things come out of it. One, people that work at the United Nations or missions live 24/7 under stress. Lots of problems. lots of dealing with it, whether or not they're in an office or outside. A number of times I would speak to people who didn't necessarily trust other people, either other employees at the UN or others who work for different missions. The concept of being able to pull together a trusted group of people, whatever their experience, former mediators, former lawyers, former construction people. I mean, of course, with the UN, it would be a different type of skill set, but that concept adds a sense of security to people who live in insecurity and who live in non-trustingness. And so what you're talking about, whatever the field might be, people who are in a given industry tend to be working in that industry, tend to have allegiances to their employers, or their ownership or their boards. And so that's interesting to put a mix of people together that might have parenthetically conflicting or competing allegiances, but to present the fact that we are able to bring you a quote unquote board, small b or capital B, of people who can assist, who have no ties to your employer, to what you're looking for, and so forth. All of a sudden, there is a different type of angelic presence, and that's what they really want. It's nice to go into the fight and we're going to mediate this or we're going to arbitrate it, we're going to beat them. But most people know that there's a chance that they won't. And so to lay it at the feet, not just of an arbitrator, but of a small group of people whose allegiance is a goal, I think is quite important.
Hi, Elizabeth Tippin in San Francisco. Having been appointed on about 20 dispute boards, primarily in the construction arena, you know, my experience is it certainly is applicable to other industries. And I think it's important to have a diversified board. You know, it is important to have someone who is knowledgeable about the technical information about that particular industry. But also, most of the successful boards that I've been on have one attorney, at least. And everybody, you know, in the construction industry, everybody that's on the board has construction experience, whether they be an attorney, a contractor, an architect, an engineer, or a construction industry professional, you know, having worked for major construction companies. And I, you know, think that in the very first meeting, which we call the kickoff meeting, typically at the kickoff meeting, the dispute board presents operating procedures. So they are more detailed than the rules for CPR, and they're up for discussion, so that whatever needs to happen for this particular industry, you know, all of the DRBs that I have been on typically meet every 3 months at the site to meet with the people face to face, to do site visits. The process provides for a way to get information. And typically there aren't disputes at the first meeting if it's held within, you know, a month or two of the initiation of the project. But a lot of times DRBs are used for ongoing projects. And so if you're in an industry where there's been, you know, say Boeing airplanes, there's been, you know, purchases of airplanes for years, and now they've decided that they have some ongoing disputes and they want to use a DRB for that. It may be that there's, you know, some things that are already positioned, but having somebody who's knowledgeable about that industry, I think is is critical. Not only people who are involved in dispute resolution processes. So I'm very excited about the CPR program, and I participated in developing the rules. I haven't studied the final draft, but I'm looking forward to participating in the program itself.
And I would say to anyone, if you are interested in, outreach to an industry that you're a member of, we're more than happy to work with you on a presentation or something to an industry that where this could be beneficial. Are you talking, Jerome? Because if you are, you're on mute.
I think we should not discount the participation and skills of attorneys, or judges pro tem, arbitrators, in being able, whether or not they have that background with reference to a specific industry, usually, often, hopefully, there is a background with reference to, pardon the word, leadership, guiding, keeping people on track, and so forth. So the presence of a person with that background, I think, is also important for these types of boards. We used to, I'm from Manhattan, but I'm now in Arizona. When the law school in Tucson was putting up some new buildings, I worked with someone who gathered together representatives of every one of the trades, both from the contractor down to the subs, as well as administration. And those few days of having people getting to know each other, understanding who to reach out to if there's a problem in a specific field and so forth, was invaluable as the project moved forward. The DRB, DRS, the concept is similar in nature. It is affording an opportunity to those who need the opportunity, the people behind the money often, to understand and know that they have unbiased outreach for advice and for guidance.
And I think please go ahead.
I'm sorry. I think that's a really good comment. What are the skills necessary for a DRB member? You've got to understand the technical information. You've got to be able to work with other people, because there are disputes between the DRB members that need to be resolved. You've got to be able to write an opinion that is going to be accepted. Your goal is to have it accepted by both parties that are in a dispute. And they both may disagree with, or one may disagree with something that's said, but you have to write in a convincing way. Particularly, I think that arbitrators are skilled in writing for the losing party. And you've got to be able to write for them so that they will know that they've been heard, and know that with the experience of 3 neutral people that listened to everything, understood everything, and came to a certain opinion. And that's where the beauty of this process really comes through, to get people to, you want them to, the goal is to get them to agree that what the dispute board has come up with is going to be accepted by both parties.
And sometimes, Elizabeth, that's the most important thing, because when a party, quote unquote, appears to have lost, if it's explained to them, if they understand, if they grow through it, they're also winners. And when you say 2 parties, sometimes I'm involved in a construction litigation. There are literally 15 subcontractors that are being sued by the contractor, who is being sued by the owner of the property. So often it's not just two, often it's more than two, and that's where this concept is even more important. The trustworthiness, the creditworthiness of the people constituting the board and their experience.
And, you know, I just wanted to say for construction cases, a lot of times we call those subcontractor claims pass-through claims, because your dispute board is really between the owner and the general contractor. Those are the parties who enter into an agreement to use the dispute board. But the subcontractors are integrally related to the entire project, and a lot of times they have pass-through claims that the general contractor is submitting to the owner for you know, a change order that's been rejected or something on that order.
One of the things that, one of the skill sets when, as Mike explained, we actually developed a questionnaire that went out to all of the people who expressed interest in applying to this panel. And one of the things that we were looking for was project management skills, because it was felt that that was one of the key ingredients in being able to, especially for a chair, to run a dispute board. You know, understanding how all of the different stakeholders, and some of the stakeholders may not be in the room. You know, they may be the people who are protesting the construction project, or, you know, who don't want it in their neighborhood, or, you know, things of that nature. So it's being able to understand how the project is, or the endeavor is going to affect all of the different stakeholders, and to make everybody understand why the decisions were made, as you said, Elizabeth, writing for the non-winning party or parties. So if no one has any more questions or want to bring up anything else, maybe we should all go and have a real drink.
Before we drink, what's the best way to make the contact to get the questionnaire that you just discussed?
So the best way is to reach out to me at this point, and I will send the questionnaire. Right now, I think we have cleared 93 people, I believe, to take the training if they are available, and May 29th is when the training is going to be. I will see if we can convene the review board before then, if we receive your questionnaire back. If you can turn it around right away, I'll see if the review board can review and now, Jerome, you actually have DRB experience, correct?
I have had DRB training. I have worked in situations that would not formally be called a dispute resolution board.
Okay. All right. I'll send you the questionnaire.
Thank you.
Thank you so much.
Thank you for coordinating this and getting us on.
That's all Micah.
We can blame him for making it happen.
Terrific. Thank you. I'll say goodbye.
Thank you for the program.
Thank you.
Thank you.
Bye.
Thanks, Elena. There's Miss Deborah. This is family.
It is.
I mean,
It's a team.
Dispute resolution people are family, especially the ones who are more drawn towards mediation. There's something about, for the most part, the hearts that come with the presence. Be well, everybody. God bless. Safe summer.
Thank you.
Thanks. Nobody wants to sign off. Be well. Bye-bye.
Well, we
Thank you.
can't, we're the hosts, so we have to wait
and-
till everyone else signs off.
Okay, well, I'm gonna stay. I'll see you all. Look forward to being in touch with you, Helena. Bye-bye, all.
Thank you.
Bye. Thank you, Deborah.
Thank you both.
Thank you, Michael. Thank you, Helena.
Thank you.